Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's go to Louisiana. Not Louisiana, for everyone who wants to say it's Louisiana. I went to Tulane, so I'm going to say Louisiana. This is, I think, a good nationwide holding. I know it's related just to the statute, but I think it's very, and even the court kind of looks to other courts. So let me tell you what happened here. So we have a Louisiana Court of Appeals, so a higher court, has reversed a lower court, which is good because the holding at the lower court was very disturbing. We have a firefighter who was diagnosed with NK/T lymphoma, right? A fairly rare disease. And under the Presumptive Act, the employer has to pay. In this case, I think it's after 10 years. If you're on the job after 10 years, then there's a rebuttable presumption that if you get certain types of cancer, and this was one of them, that it's related to the job, and they have to pay you certain benefits. But the term rebuttable presumption means, right, for everybody, if as long as the person requesting the benefits has made a good faith basis to say why I'm entitled, such as I was on the job for more than 10 years, which does it, and I got cancer, right? That's enough for them to do. Then the burden shifts to the employer to argue that no, it wasn't caused by the time on the job. It was caused by something else. And what happened here is, I think, extremely important for all fire departments who have these cancer, statutes, presumptive cancer statutes across the nation. The district court, which is reversed, but the district court puts on a couple of doctors or listens to a couple of doctors. None of the doctors could 100% say that this cancer could not be exacerbated, not caused, exacerbated. So your risk of getting this cancer, they couldn't say 100% could not be exacerbated by time in the fire service. And they said it's not likely, it's highly unlikely, we've never seen a case of it, there's no proof for it, but no doctor could say it's 100% not caused by exposure to other chemicals, which fire departments are exposed to. So based on that theory, the Court of Appeals reverses, removing, to me, placing a good burden on the municipalities, right? It's a new rule, as I interpret it, a new interpretive saying, no, you've got to prove 100% that it was impossible for anything in this case, 30 years, but in the minimum 10 years to have increased their chance, not caused it, but even increased. So if you're an employer and you're going to argue, at least in Louisiana, but I'm going to argue in now many other states, this case really does the firefighter justice, right? Even if it increased the exposure chance by 0.25%, that's enough to defeat the shift burden presumption, or a shift burden's defeat, I guess, to the employer. So this was a great case, and whatever else you want on this.
Yeah.
But
well, I feel strongly about this, that cancer presumptions are the right way to go. I know many people say, how are the taxpayers supposed to be responsible for this, and so on and so forth. But the bottom line is, when someone gets cancer, there's going to be economic harm, period. There's going to be, now, whether or not it's going to be borne by the fire department, whether it's going to be borne by the member and his family, whether it's going to be borne by the taxpayers again, because the person is basically exhausted all of their resources and now is on some sort of federal financial assistance, Medicaid, Medicare, whatever it may be. The bottom line is, someone has to pay for it. So who's in the better position to be able to pay for it? Are we better to put it on the federal government? Are we better to put it on the individual employee who likely could end up bankrupt and from medical bills? Or does it make sense to put it on the employer, who then can insure for it and address it that way? And I'm making the case that it really should be the employer that is doing that. Now, the other thing is the science behind it. I think that there's cases, there's research that goes both ways. Some research says cancer is no more common in firefighters or just marginally higher in firefighters. There's other research that suggests that it's substantially higher. Okay, so point being, there is no doubt that firefighters are exposed to carcinogens. Okay, there's absolutely no doubt. You go to a car, even a car fire or a dumpster fire, never mind building fires, you are absolutely positively exposed to carcinogens. And so there's sort of a bargain there that you're saying, all right, look, you're going to go and think about this from a business perspective. Okay, I'm going to hire somebody and I'm going to expose them to carcinogens on Monday. And then I want them to come back to work Tuesday. Well, they got exposed Monday. How do I induce them to come back to work Tuesday and get re-exposed, and then Wednesday, and then Thursday, and then do it for 30 years? So the part of the bargain here is that, look, we're going to expose you during your course of your career. We're going to do everything we can to not expose you, but the bottom line is you're going to be exposed. Part of the bargain here is going to be that if in the event that you get cancer, we're going to cover you. And I think there's a strong economic reason why this makes a lot of sense.
And you said it perfectly. Yeah, you said it perfectly. And for the employers to cry, oh, it's too much for me. Wait a minute. Well, then you get cancer. Right.
Right. And if it's too much for you and you're running a business, how can you dump it on your employee?
Right. That's exactly. That's like GM.
They're not millionaires. They wouldn't be working for you if they were millionaires.
Right.
Right. So, how can you say it's too much? And you can plan for it. You can insure for it. You can add it to your workers' comp coverage. You're going to pay a little bit more an hour, but there's mechanisms in place for you to absorb that kind of increased cost.
And look, the most governments that I've seen, New York has, and I've read a lot of the others that have these presumptive cancer laws, they do something that's unfortunate for the firefighter, but they take a halfway point. For example, in New York and many others we've seen, they say, listen, you can only file a claim once within the 5 years after you've left the fire service. So if you've left the fire service.
Yeah, because you and I talked about this last week or the week before.
Yep.
And I noticed that you've got there's a link in there. You can click on it for the folks who are listening and go right to the Louisiana law, but it has that 60-month, 5-year limitation to it.
Very common, very common. And that's just a recommendation or a recognition that, listen, we want to give you something, but we're not going to do it forever. So, you get a firefighter who joined at 20, retires at 45. If they don't see the cancer they got by age 50, they got 40, 50 years of life left. They're on the hook for it. So it's not like we're doing a huge disservice to the employers. The employees aren't covered for that long, unfortunately.